I'm not a lawyer, but as expected, Brian Steele left that courtroom today and immediately went to filing motions. Let's start with the first one. It's a motion to invalidate and strike all proceedings that occurred in the above referenced case on and after the initial motion to recuse Judge Glanville was filed on June 12, 2024. Mini plug right here to say that I interviewed attorney Kayla Bumpus on my podcast, and she actually brought this exact point up on the podcast as well. So go watch it. I talked about this a little bit in my last video because Brian Steele said it at the hearing, which is basically that Judge Glanville denied the Honorable Attorney Weinstein's motion to recuse on June 12, 2024, as well as the motion filed by Brian Steele on June 17th. Both of the motions were denied, but since both of these motions had merit and were later granted, all proceedings that occurred after the first filing on June 12, 2024, which includes the testimony of Kenneth Copeland, all of the exhibits that were admitted and displayed to the jury, Judge Glanville's rulings and evidentiary issues, and the like, must all be erased forever from the jury's mind, and any rulings that occurred in front of and outside of the presence of the jury are invalid. Now, I'm not a lawyer, but this seems to be the problem. How do you tell a jury, hey, everything that you saw and heard from June 12th until right now, forget all that, forever? The motion says that Mr. Williams respectfully requests a hearing on this motion. What they are asking for is that the jury be instructed to remove all notes from the relevant time period, meaning June 12th and on, and erase from their minds the invalidated testimony and rulings in any other matters that occurred during this relevant time frame. The other motion that Brian Steele filed today is to challenge factual findings not result of the Honorable Judge Krause's order from July 15th, 2024 that granted the motion for Judge Glanville to be recused. So Steele is saying he's not challenging that Glanville was actually recused, but he's challenging what Judge Krause wrote in the order to recuse him. First thing he's challenging is this quote from Judge Krause, which says, "Divorced from its hyperbole," which basically means once you take away all the theatrics and exaggerations from the motion, Mr. Williams' motion sought to recuse Judge Glanville because of his involvement in the ex parte meeting, which Mr. Williams also alleges was improper and coercive. So in response to that, Brian Steele is saying there was nothing hyperbolic, exaggerated, or dramatic in his motion. And then the second issue Brian Steele is taking up in this motion is another quote from Judge Krause, which says, "It is worth noting that the Honorable Judge Krause agrees generally with Judge Glanville's assessment of the propriety of the ex parte meeting. While the meeting could and perhaps should have taken place in open court, nothing about the fact of the meeting or the substance discussed was inherently improper." I talked about this in the first video when she actually issued the recusal, which basically was that Judge Krause said ex parte meeting itself was not a problem. It is what Judge Glanville did after that meeting why she recused him. And here Brian Steele is saying, no, that's wrong. He says, quote, "This finding is wholly against the law. At this improper ex parte hearing, Mr. Williams and his counsel had a right to be there for several reasons," and then he lists those reasons. He finishes up this motion by saying, "There are more reasons that these findings in quotations, is sending me, by the Honorable Judge Krause are completely erroneous, but same do not affect the outcome of the correct ruling recusing the previous trial judge." So again, he doesn't have a problem with Glanville being recused. He just wants on the record that the ex parte meeting was improper, that his motion was not exaggerated and hyperbolic, and that the jurors need to somehow erase everything that they heard from June 12th onward. These motions could be the perfect groundwork to a motion for a mistrial. But I'm not a lawyer, so we'll see. You can expect a number of motions to be filed in the coming days for this case. And then the state will respond to those motions, and then the week of July 30th, Judge Whitaker will go through each and every one of these and start issuing some rulings. So don't expect any really big, impactful rulings to happen until then.